I don't know. After hearing him calm and talking about the Tether story, it's probable.
Let's go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. Yeah. There we go. I still getting used to the buttons, apparently. What's going on? This is Colin. How's everybody doing? Night of Knee! Night of Northern Ireland or Night of Knee. Welcome. Night of Knee is a friend of mine that I've had around for a long time, and this is the first time he's graced us with his presence on my channel. Night of Knee, welcome. I appreciate you being here. All right. I've got a SovCit. The same SovCit that I've played a few times. This is, I think, the third or fourth time that I've covered him. He's back in front of Judge Perkins. And it is good. I don't have to say anything else. It's a SovCit that, you know what? Let's just go. Everybody, Debbie Baker, thank you so much for coming. Jojo, Michelle, Phil, Nancy. Who am I missing? I'm missing a lot of people because I just jumped in here. Philip, how's Australia? Scrolling. I got Johnny May. Welcome. Mimi, as always. Glitterfart. Everybody, thank you so much for coming. All right. You guys ready to be entertained? Also, my background is still the Bengals. So we're gonna let that roll because the Bengals are gonna beat the Jaguars tonight, right? Hopefully. Please. All right. Before I hit the play button, you already know what to do. Please like and subscribe. Do your jump kick backflips. And why am I looking rough? Heineken. He's one of my favorite trolls. Heineken's cool though. All right, like, subscribe, jump kick, backflips. If you love this video, my link tree is in the description, and you can donate. Let's go.
Detroit versus we already called the Javar Tyrone Grayson matter. Let's go back on the record with Javar Tyrone Grayson. Mr. Morgan, can you put your appearance on the record, please?
Stephen Morgan on behalf of the city of Detroit.
Okay. We have a situation here where Mr. All right. We have a situation
that wasn't T. Higgins, but
Mr. Javar Tyrone Grayson has a jury trial set for tomorrow. And what I wanted to go over with the court, now this is Grayson Bay, let me get that correct. Mr. Grayson Bay, I did receive
already
the
started off good.
documentations that you had.
Can always fight over football.
He has a table of contents here. He has a declaration of nationality legal notice, declaration of nationality, name correction, proclamation, public and publication, judicial notice and proclamation to all elected United States Republic office and public servant of federal, state, city, and municipal governments, personnel and corporate entities concerning the Constitution and all statutory and civil law codes of the land, know all men, etc. Know all men be these present.
I hope not.
Grayson Bay, one. See, let me strike that. I, Grayson Bay, being duly affirmed, standing squarely, declare and proclaim upon divine law, naturals law, universal law, Moorish birthrights international law, and constitutional law, declare and say, I being previously identified by the Union States Society of North America USA under the colorable warship name Javar Tyrone Grayson, do hereby refute the fraud, semicolon, make public and publish my corrected national name, declare and affirm my true proper person status, and reclaim my rightful social and cultural life of the state, semicolon, in accord with my ancestral Moorish nation of Northwest at a Maxims, North America, acknowledging my birthrights, period. Having lawfully and legally obtained and proclaimed my nationality and birthright name and title, semicolon, I strike that, in harmony with, in association with, and in accord with divine law, the customs and the laws, period, rules and usages of the Zodiac Constitution, semicolon, being aboriginal and indigenous and bound to the North American continent by heritage, by primogeniture, by birthright, by natural birth, semicolon, by freehold, and by...
That's a good ass question. Why is the judge reading this? But it's good though. I'm glad he read it.
by inheritance, period. Declare for the public record, I am entering, strike that, I am returning to the European cognomen and fictitious misnomer back to the colonial processors of its pedigree, period. I am not rightfully declaring, publishing, and proclaiming my own free national name, affirming my actual, rightful, and civil in full life status, conjoined to my ancestors, Moorish American consanguine pedigree and national honor, semicolon. Let it be declared, known, published, and resolved that I am Grayson Bay in proper persona sua soi juris, being in my own proper person by birthright, semicolon, I am Moorish. I'm not going to continue to read the rest of that.
Thank you, Your Honor. Well said, though. Thank you.
I just don't have a clue of what's going on with this.
Just a declaration of my nationality, Your Honor. Thank you, though. Well said, though.
Okay, so in how, what am I supposed to take of this? You know, are you saying you're not American?
I'm Moorish American from the
Okay.
land of Exuma, Turtle Island. The issue is the corporation of United States, and that's the issue. And I'm under a natural law as Grayson Bay. I'm in natural form now as a man. And Yeah, I mean, you said it excellent. You pronounce things perfectly. Yeah, but that's my
All right,
nationality.
so let's
And
get to this
once
one
again,
here.
What Turtle Island is he from? He's from a Turtle Island. Oh, this guy. Again, this is my third time covering this guy. He never disappoints though.
I did proclaim that the court didn't have jurisdiction over me. That's where we were at.
All right,
Over jurisdiction.
and I had you sit in on this, Mr. Let's say, let me stop for a matter, stop the record. Miss Tucker, are you ready on Mr. Greer or not? You're not.
No, Your Honor, I need to speak whenever Prosecutor Morgan gets a chance, if he can come in the breakout room.
With Mr. Greer and you?
Yes, Your Honor.
All right, Mr. Morgan.
Judge, I'll meet him in the breakout room. For this matter, you know, Miss Schneider I guess she's assigned and she's going to be handling this matter. You said it's set for jury trial tomorrow.
Yeah, what I wanted to do was this, because I mean, I'm prepared to rule on some of this without even a jury trial. The only matter that the only matter that I was really is the false name issue, which is what probably I'll let a jury decide on that, because this other stuff, that's why I had you on. There was an opportunity. These were things that were filed, that he had filed, and I don't know if you've read them or had a response, or I know you probably haven't, but your office. It says, notice to all law enforcement, nationals or citizens are not required to show identification to a police officer.
Yes,
so
Liam.
What I'm going to do, he cited a Supreme Court case, Collin versus Lawson, 461 U.S. 352, 1983. And it says, in which the United States Supreme Court ruled that a police officer could not arrest a citizen merely for refusing to present identification. Now, I'm not even going, did you get arrested, Mr. Grayson Bay?
I was obtained.
So if there's no arrest, then how is this even pertinent here?
And under my jurisdiction, that's an arrest.
Well, we're not under your jurisdiction.
Once he touched my vehicle, it's a violation.
Well, listen, I don't recognize your jurisdiction in this court. I recognize the state of Michigan ordinances and laws and the Michigan court rules. So I'm going to conclude that this based on this document that you've given me, this would be your lead case, that I'm not going to consider that necessarily an arrest. You weren't taken into custody, were you?
Yeah, he touched me.
I know. Okay, that's yeah. I don't have anything. If that's your authority that I just read as far as your Morris Nation,
Common law.
I don't understand that.
On your honor, also I'm not asking for a jury trial. I'm asking for you to make this decision. I'm asking for you.
But I told you that I'm not going to waive your jury trial rights. You're going to let
I don't want a jury trial. I want you. I trust you.
It doesn't
Yeah,
matter.
I trust you. I think you can make a firm decision and what's going on here. I'm pretty sure you see.
I'm going to make a decision right now on this stuff right now, on most of it. All I told you I'm going to do is the failure to ID.
Oh, shoot. I don't want this to hang up now.
The failure, false info and ID. I'm not going to make a decision on that. I'm going to let a jury make the decision on that.
I'm not really getting an understanding. I mean, I don't think you can even find 12 Morris people to even judge me with my peers. I mean, I'm not even going to consent to that. So I don't understand.
Well, how
that.
are you going to let me why do you want me to do it? I'm not Morris.
Well, then you need to I'll file a motion to dismiss this case.
Is that what it is?
Yeah.
It's not going to happen.
Okay.
You got to file those motions on your own.
I'm telling you verbally right now. I'm filing a motion to dismiss this case.
Okay, I'm going to dismiss. I'm not going to grant the motion.
Take it to the next level.
Motion
I'm not
denied.
paying. I'm not paying. That's just it. I'm
You're
Morris
not what?
American, man. I'm Morris American. Okay?
I'm not going to go back.
That's my birthright.
Listen, I understand that. Listen,
Right.
I'm not going to go back and forth with you. I'm not disputing.
Right. I don't even think the prosecutor even wanted to attempt to even battle this. And it's not even against you, Judge. I understand your situation. You wants to be the ref. You can be the referee in this, but I don't think the prosecutor even want to go through this.
All right.
Motion to dismiss, Your Honor.
I'm not gonna grant it.
Okay. Well, do what you do,
Mr. Morgan, go ahead and speak with Ms. Tucker and Mr.
You know what? This guy has balls, though. Motion to dismiss, not granted it. He's trying, though. Heineken. I love you, man. Heineken's my favorite troll. Oh. What do you even say? I got to stop it every few minutes, so I have to stop it, but I don't even know what to say. This does not get better. Just so we're aware. This does not get better.
Mr. Greer.
Hey, Walter.
All right.
All right, thank you. Ms. Tucker, can you go back to the breakout room? Just
She's ready
tap
to
your
go.
prompt. Tap your prompt, please.
Your Honor, I need you to accuse yourself of this case.
Your
All right.
Honor,
No, I'm going to continue on. So that's the case he
I'm
cited.
filing motion.
Did he just say, Your Honor, I need you to accuse yourself of this case? So he needs to accuse himself. So he has to put himself. Yeah, he's accusing himself. Yeah.
So for you to accuse yourself.
I'm going to deny it.
Okay. Well,
You can put it in writing. I'll deny it. So let's continue on with this notice to all law enforcement that the Supreme Court case was cited, and I haven't read that case yet, but I'll look it up. There is no such thing as failure to identify. You can sue the police for an illegal arrest and resist arrest with impunity. Okay. So he cited some cases here, State versus Robinson. Looks like a Maryland case. State versus Mobley in those North Carolina case. State versus Adams versus State, Georgia case. And I guess you're saying on those cases that the person did not have to. You can sue the police, that they sued the police and successfully sued the police for their arrest and resisting arrest.
Your Honor, excuse me. I also have Thompson versus Smith, the right to travel.
Well, that's on the next. I'm going under the failure to identify heading there.
Oh, okay.
That's under the next heading. So the next heading is personal liberty, the right or power of locomotion, of changing one's situation, or moving one's person to whatsoever place one's own inclination may direct without imprisonment or restraint, unless by due course of law. Unless by due course of law. Now I don't know where you got this. If this is a law, you didn't cite anything from that.
It goes on into Thompson versus Smith, the right of a citizen to travel.
Okay, the right of a citizen to travel upon a public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege with a city, which a city may prohibit or permit, at will, but a common right which she has under the right to life, liberty, and the pursuit of happiness.
And again,
I believe I've
there's
read this.
Merlot versus.
Hold on, wait a minute, wait,
Pennsylvania.
let's deal with this one right quick. Let's not get ahead of ourselves.
Okay, no problem.
All right. Well, we're not getting ahead of ourselves. I am going to thank a few people who have super chatted me. I just received one from Tranquility. Thank you so much. So the name of her business, I'm assuming. I don't know what your name is on YouTube, but your business is. I hope you're doing well, and thank you so much for the super chat and the kind words. Also, Rose and Sheila, thank you so much. If anyone else would like to super chat, my link tree is in the. And KCC is here. So this entire chat is going downhill now because KCC's here. Joking. KCC, good to see you. You don't jump over here very often. I don't know. But thank you. Everybody. Let's keep going with this argument. And yeah, KCC, sorry. My English is horrible right now. I'm just trying to speak. Not very well.
All right.
I deserve that.
Okay. I think
deserve
this is a case that I've read before.
Judge Perkins is studying right now. Studying hard. What are we gonna do, Judge Perkins? What are we gonna do?
What are you saying? What do you believe this case says?
Are you referring to me, Your Honor?
Yes.
It says what it says. I'm just waiting on your decision. I'm here to defend my birthright and my nationality. When you say that 5-pointed star on the street, leave me alone. That's my nationality. That's all I ask for. We should be questioning the officer for even bringing me to you. They got to have respect for that nationality, and that's all I'm here to prove. My nationality and my birthright. All that other color stuff and colorism calling me black, I'm not permitting that. I'm sorry. You're not going to pull me over because I'm driving around black. That is real. DWB is real. But when you turn around and have a nationality, that's where it stops. He probably shouldn't have brought me to you, and that's the issue. We should be holding him accountable for his actions, not you or the prosecutor. I'm pretty sure the prosecutor don't even want to battle this. But I'm going to stand on my birthright and my nationality. That's my right. That's my common law. I'm very passionate about it, Your Honor, as you can see. So if I seem a little upset or if I get a little, mischief at you, I'm sorry. I apologize for that. But my birthright will stand. I don't want to be a United States citizen no more. I'm not subject to United States no more. I'm tired of paying taxes. I can't even afford the insurance. My birthright is all I'm standing on. That's all I have, Your Honor. All due respect. I'm Morris American. I'm indigenous to this land. Nobody dragged me from Africa. This is my land. And you're going to respect me when you see that flag. Thank you.
Okay. Let's go back to what you filed here.
Anyone else think it was funny that dude just went off and Judge Perkins, okay, moving on. It was good.
Thomas versus Smith, 1 54 Southeast 579. I think you need to read that in its entirety, because this is one of the cases that I've seen before that has been filed, and it appears to the court that it's saying exactly the opposite of what you believe it's saying. It is saying that the city can revoke your license. You don't have the authority to operate a vehicle on the city streets.
You want to battle the dead entity. That's what it is. You want to charge me on this dead entity side, and I can't.
No, I don't know what you mean by charging on
This
the dead.
dead
I'm
entity,
going by. Wait a minute. Here's how it's gonna work. I'm gonna talk. You're gonna listen. I'll let you talk.
Yep.
I'll let you talk. I'll listen.
Let's get it. You're right.
You filed this.
That's right. You get it.
You cited this case law. Okay, so you're saying, and I'm giving you the benefit of going over this stuff.
Thank you.
This is another case that I'm gonna that you cited, that I am going to tell you that it's actually Shuttlesworth versus Birmingham. This is the court actually takes offense to you filing this.
It's a court case.
I do.
It's a court case. How will you be offensive?
I'm taking offense to you filing this and using this in your filing as a reason for you not to have a driver's license. And I don't know if you've read this case or not. It doesn't seem and appear that you've read any of these cases thoroughly, because I've gone through each one of these cases at different times, and if each of them say exactly the opposite of what you appear that it says. And the Shuttlesworth case goes back to a time in history where we're still dealing with, where Reverend Shuttlesworth was a reverend in Birmingham, Alabama. And you're citing this case to saying that Shuttlesworth was saying that he can drive without a valid driver's license.
Definitely travel.
That analogy to this case, and it's saying nothing of that sort. And I wish you would take time and read to what this case is saying, because I don't even think you, as a Moorish American, would I think you would retract this case law right here from what you've filed. You're using the people in the civil rights era who are trying to fight for their rights to march or down a public street. That's what this case was about. He's taken his congregation down a public street. He walked them on the sidewalk. He did not interfere with any traffic, and he crossed the street not against the lights or anything, and they still arrested Mr. Shuttlesworth for not having a license to congregate.
Yeah, that's true. Yeah,
but
you're right.
When you're saying that he needs to have a license, that is analogous to you not having a license to drive.
If he want to proclaim he's black, he needed a license.
All right, I'm done with this. I've spent enough time on this, and as what I'm going to do is I'm going to rule on the cases ahead of trial for the refusal to exhibit driver's license. I'm going to find you guilty of that. For the refusal of for having no insurance and no proof, I'm going to find you responsible. I'm going to find you responsible for an expired plate. We'll go to trial on the seatbelt, on a formal hearing on the seatbelt issue tomorrow, and the false ID tomorrow. All right, that's going to be the ruling of the court. If there's nothing further, Mr.
Yeah, there is, Your Honor. Can you send that information in writing? You have the address.
It's going to be on the ROA, and you can get a transcript made up by the court. All right.
Okay.
What time you gotta be?
What time is court tomorrow?
It's gonna be, come on at 8:30.
Okay, you're gonna do this again? Because
Well-
no jury trial.
It's
Just
gonna be a
you.
jury trial, all right?
I want a jury trial.
But you
I
don't
will
make the
represent that.
rules. This
But
is my
tomorrow,
courtroom.
tomorrow I'm
This
just
is my
gonna put a
courtroom.
request in and
Jury
that I
trial
can say.
tomorrow.
Okay, I'll see you tomorrow.
Very well.
Your Honor, this is the prosecutor. I just want to find out what counts I need to communicate to my office that they're going to be a trial on.
We're gonna be on SP 146390002. We're gonna be on a formal hearing on that. SP 146390001 is gonna be dismissed. I mean, strike that. Is gonna be responsible. SP 146390003 is gonna be responsible. SP 1464091 is gonna be guilty. And that's based on the filings that he's filed. And then SP 146436761 will be trial. Formal hearing, trial. Tomorrow, December the 5th, 2023, be here at 8:30. We'll get ready. All right? Have a great day.
Thank you, Your Honor.
Have we come to a resolution on Greer?
Yeah, sure.
All right, yeah. Jury trial tomorrow. I highly doubt that's going to be on YouTube. But if it is, I will grab it and we will watch it together. You know what? If it is on YouTube tomorrow, I'll just start it live. We'll just have a live stream. We'll have a party with it live. Let's do that. But I really don't think it's going to be on YouTube. But we'll look. We'll look. All right, that was case number 1. I got another one. How do you beat a sovereign citizen? You can't. As Glitterfart would say, you can't beat a sovereign citizen. But what you can do is you can one-up it by bringing some barbers to court in hopes that you don't get a violation because you're on probation for alcohol and your tether sparked up negative readings or positive readings, whatever those are. Yeah. All right. Head into Judge DiSanto. If you haven't done it already, please like and subscribe. Do your jump kick backflips and link trees in the description if you like the video and want to donate. Let's go. This one's a little bit more fun than the last one. The last one was everyone yelling. Judge DiSanto has a power ponytail on in this clip. I think it starts right now. So,
Mr. Shanti?
Yes, I see, Judge. I'm joining now.
Okay, thank you. All right, we're going on the record in the matter of Matthew Sneed 23270.
every once in a while they do. Depends what courtroom you're in. I've seen a couple jury trials. I just did a whole series of a jury trial last week. So if you want to go look, there is a jury trial. The jurors aren't on camera, but they do jury trials on Zoom. This is why I got to think about what I'm saying before I say it. They do jury trials on YouTube. They don't really do them on Zoom unless you have a really good excuse not to show up. The people in the trial show up in person, but they will play them on YouTube. All right, there we go.
And counsel, your appearance, please.
Good morning, Your Honor. Attorney Thomas Courts appearing on behalf of the defendant who stands to my left. Please state your name for the record, please. Matthew Sneed.
Okay. All right, and okay, Mr. Stradley, can you please state your name for the record? Mr. Stradley?
Sorry, Your Honor, I was technical difficulties. Jeremy Stradley, EMS Tether. Your Honor.
Okay, thank you. All right, so here's what, so Mr. Sneed is on probation for operative visibly impaired. And he was sentenced April 27th, he had a probation violation hearing on November 6th. Whereby this court, where he pled guilty, this court sentenced him to 5 days jail, 30 days on the alcohol tether, mandatory additional jail for any future violations, outpatient treatment, extend probation 3 months. Then it's alleged on the 13th, he failed to appear for drug testing and tested positive while on the tether. And then on the 27th, he pled guilty, but then we adjourned the sentencing for today's date so that Mr. Stradley could testify based upon what Mr. Sneed indicated the reason why he tested positive was. And so, Mr. Stradley, if you can please state and spell your first and last names for the record.
Jeremy Stradley, STRADLEY, EMS Tether.
All right, thank you. All right, Mr. Stradley and Mr. Sneed, please raise your right hands. Do you solemnly swear from the testimony about to give this man with the truth, the whole truth, and nothing but the truth? Mr. Sneed.
Yes, Your Honor.
Mr. Stradley.
Yes, Your Honor.
All right, thank you. Okay, and so, Mr. Quartz, if you're okay with that, I'm just going to kind of summarize for a moment. So Mr. Quartz or Mr. Sneed stated that the reason he tested positive for alcohol was because he received a haircut and a shave.
Aftershave lotion.
Or sorry, aftershave was alcohol. Only alcohol, if I recall correctly, right? It was pure alcohol.
Yeah, so I do my research throughout this week.
Hold on, sir, hold on. Your testimony last week was that you had pure alcohol put on your face and your hair,
Yes.
your head.
Yes, Your Honor.
Okay. And so because of that, Mr. Sneed tested positive for alcohol on the tether. And refresh my recollection again, sir, your haircut was at 8 p.m.?
Yeah, you didn't get
Yes.
to 8:30, yes, Your Honor.
So your haircut started at what time?
8:30,
And when was your haircut complete?
about 9:15.
Okay. And so, Mr. Quartz, did you want to ask Mr. Stradley any questions?
If you allow, yes, Your Honor.
Yes, okay.
Sir, if I might ask, are you trained to identify what could cause this device to go off?
Yes, sir.
And do you believe that training has equipped you to determine all causes that would trigger this device?
That training is the,
Oh,
I'm sorry?
specifically, I guess I should ask, do you feel that your training and experience have equipped you to definitively answer the question if a large amount of aftershave on the face and hair on the head as well could trigger this device?
It could, yes.
That's all I have, Your Honor.
So your testimony, Mr. Stradley, is that pure alcohol on the face and the head of Mr. Sneed could give a positive result on the alcohol tether, on his
My,
ankle.
my apologies, Your Honor. The court misinterpreted, so did the attorney, and I misanswered. My response was yes, I can dictate the difference between the two. That's correct. However, in this instance, we have multiple peaks to a point, Your Honor. There's been multiple studies done as far as the absorption of alcohol through the skin. It's just not. It's just to get to these levels in this kind of time is not a feasible thing, Your Honor. We have multiple individuals that are barbers, nurses, etc. Their hands are in contact with alcoholic substances all day long, to include bartenders, and we don't have these kind of issues.
Okay. So I think that was some clarification on that. The court asked a question based upon your question. And so, Mr. Courts, do you have more questions now?
If I may, Your Honor.
Yes.
Sir, are you familiar with a Barton Morris?
I'm familiar with the firm, yes, sir.
Okay.
I'm
And
sorry, a what?
Barton Morris. I could spell it for the record.
Yes, please.
BARTON space MORRIS.
Is that a person or?
Yeah, it is a person that would normally testify in these matters. Unfortunately, my client can't afford that. And I don't know if now is the time to address a preliminary question, Your Honor, about this, or you want to proceed?
Okay, and so Barton Morris is a person.
Yes, Your Honor.
Okay.
Sir, are you aware that others may hold a contrary opinion relating to this issue?
I'm not aware of.
Counsel,
I'm aware of the data
oh,
that
I'm sorry,
the court
Mr. Stradley.
provided.
Counsel, I'm sorry, Mr. Stradley, just a moment. Counsel, I think that you need to be more specific. That's too general of a question.
Okay. What study specifically are you citing when you would say that this couldn't happen? Or is that your testimony that it's impossible, or it's just not likely?
It's not likely.
But it is possible, correct?
In very trace amounts.
I'm sorry, very what?
In very trace amounts, Your Honor. The absorption of the alcohol transdermally through the skin, as it relates to getting to an elimination process, by the time the body was absorbed that small amount, it would not be even traceable on the bracelet.
Sir, do you know today what study specifically you'd be citing and relying on?
I'm sorry?
Do you specifically, what scientific study are you relying on to draw your conclusion?
That was something I learned in the state of Indiana course by it's called the Borkenstein course for highway safety and alcohol control.
And what year was that, sir?
3 years ago, sir.
At this point, Your Honor, I don't have further questions for the witness. I do have a preliminary question about my client's ability to pay for his own expert, whenever the court would like me to address that.
Okay, Mr. Stradley?
Yes, Your
Your testimony was that this could be possible, a positive alcohol reading could be possible in trace amounts. Does that the level would be a trace amount of level of alcohol indicating on the tether, or a trace amount that has been absorbed through the skin?
A trace amount that may convey to the tether, Your Honor. Again, the amounts that would be absorbed through the skin, and again, just an application to just your face momentarily is not going to get you to a 0.057 peak on our bracelet. Again, you know, as your body dissipates or eliminates that alcohol, it obviously deduces the amounts as well. So for that trace amount to be applied to somebody's face or head, to be absorbed through the skin transdermally, and then obviously showing up on our bracelet a little less than an hour later, is kind of, irrelevant. I don't believe that's the case. In addition, there are 6 pieces of criteria. All 6 of those pieces of criteria must be met to be a confirmed alcohol consumption event. In this instance, all pieces of those criteria have been met. And as to the independent studies, there have been studies by NISTA. There have been multiple Dalbert and Fry hearings regarding the technology, Your Honor.
Okay, and what are those 6 pieces that you indicated were present?
So there must be a 0 alcohol reading on the bracelet prior to the event. There must be 3 peaks over a point, peaking out at over a 0.020%. It must meet the absorption and the elimination rates. The absorption rate not being greater than 0.10%. The elimination not greater than 0.035 on the elimination side. The 5th piece is it must return to a 0 alcohol reading. And lastly, it must pass the contamination test, whereas the device itself takes a sample from the environment, testing for alcohol or ethanol in the environment around the offender. If any one of those 6 pieces of criteria are not met or contaminated, the whole event as a whole, benefit of the doubt is given to the wearer and they throw it away.
Okay. And so, and I know your testimony was a 0.057, but I'm showing the point as 0.075.
Somebody must have put that backwards. You're 5.7, Your Honor.
Okay, I'm looking at the reading on the report, and it's over, the red lines are over the 0.075. Is that Mr. Sneed's test, or is his test the black?
Oh, Your Honor, my apologies. If you're looking at the graph, Your Honor, the red line is an indicator of the ambient temperature. The middle line, which is the blue line, that is the IR voltage readings. That tells us where the bracelet is fitting to be sure that there's not an obstruction. The bottom line, which is the black line, that is the indicator of the presence of alcohol, and in addition to the alcohol readings. Each one of those dots on the graph, that indicates the test. That device samples the wearer every 30 minutes.
Okay, so there's the clarification. So that would be a 0.057. Okay.
That, if you
And
look further,
so,
the non-compliance, Your Honor, on page 4, number 2, it'll say peak TAC of 0.057 was established on Monday, November the 13th at 11:27 p.m.
it does say that. Okay, so in your, how long have you been in this profession, Mr.
9 years,
Stradley?
Your Honor. 9 years.
And in your 9 years of experience, have you had, and I understand that you have individuals that are barbers and bartenders and medical staff. Have those readings tested positive for alcohol consumption by using alcohol-based products?
What I can tell the court is in the past, generally when somebody's using an alcohol-based product and we get a reading on our bracelet, generally speaking, it's because they touched the alcohol product and touched the bracelet. However, that data looks completely different because the readings will go from a 0 alcohol reading to whatever that peak amount is. It doesn't continue to create more alcohol, Your Honor.
Okay. And it's your opinion that somebody having alcohol skin on their face as aftershave and their head would not generate a positive reading on the alcohol tether up to a 0.057. That was, it looks to be about maybe 2 hours after the event, maybe?
That's correct, Your Honor. The bracelet was at a 0 TAC reading at 9:24, which means that effectively about just before 10 o'clock, the first alcohol reading was taken, the first presence of alcohol was detected, I should say. So they're essentially that, yes, it had to meet all those pieces of criteria, Your Honor. Therefore, you have to stand behind the science. The science dictates that, this is a confirmed consumption event. We have to stand behind the science, Your Honor.
Okay. And when you outfitted Mr. Sneed with the tether, was he provided with instructions as to what items he should avoid?
Absolutely. Every enrollee is provided with a participation agreement. In addition to that participation agreement, they're also verbally spoken to. 3 things come out of the installer's mouth. 1 is nothing ever to get between the bracelet and the skin. 2, refrain from the use of products containing alcohol.
Okay. All right, any further questions from that, Mr. Quartz?
Your Honor, if I might, sir, would your testimony change if you heard 2 witnesses testify that they were with him the entire time that he wasn't drinking, and this occurred?
Sir, regrettably, the science speaks for itself and the data is the data.
On the subject of the data, what is your false positive rate on the test?
There is no false positive rate, sir. It's either positive presence of alcohol or no positive presence of alcohol. Hence the reason why there are 6 pieces of criteria, and all 6 of those pieces must be met. Any one of those are incorrect or not met, the event of the whole is thrown away. It's a pretty high standard, 6 pieces of criteria.
It seemed to be important to you to publish it and orally explain to your clients not to use alcohol-based products. I would assume that's because it has a tendency to create false positives.
That's not a false positive, it's the detection of alcohol. The only difference is whether it's a consumption or it's environmental.
Can you state today how much alcohol my client consumed that night based on this reading?
Well, hypothetically, if it's a 0.057, I would assume that would be like 3 or 4 beers.
Okay. And how long would 3 or 4 beers take to leave the system?
It's not what leaves, generally speaking, on this gram bracelet. It's anywhere between 45 minutes to 3 hours after the consumption is when we begin to detect it.
I'm sorry, is when you begin to detect it, is that what? your
That's
testimony
correct,
was?
Your Honor. So again, the bracelet itself is detecting the alcohol on basically the individual wearer's elimination phase. So as they are eliminating that alcohol, that's when we begin to detect the alcohol. Obviously, our peak is when they have finished eliminating and they start to stop eliminating. That's when our elimination phase begins.
So
Does that make sense?
this elimination phase, when you've seen the 0.057, does the elimination in the testing comport with the consumption of alcohol as it decreases in a normal human body?
As long as it meets the criteria of eliminating less than a 0.035%, that's correct.
At what time did that occur?
At what time did what occur, sir?
Did you see it meet your criteria of elimination?
Well, if we have a peak at 11:27 p.m. and then the bracelet's reporting that at 3:01 a.m. and the 0 THC was reestablished, then that would be the period there. It'd be 11:27 from the peak to the elimination when it stopped at 3:01 a.m., which gave us an elimination rate of a 0.016.
Okay. So was there testing between roughly 11 and 3, or are those just the testing periods?
As I stated before, there's the system itself takes a test every 30 minutes. As indicated, each one of those dots represents that 30-minute window test.
So I guess what I'm trying to establish is, and if you know, every 30 minutes following the read of 0.075, was the alcohol in a body decreasing as you would expect it to from the consumption of alcohol up until a.m.?
That's correct.
Would that also be true if it was an absorption through the skin?
What do you mean an absorption through the skin, sir?
would the body eliminate alcohol at a different level if it was drank or absorbed through the skin?
That I'm not concerned with that answer, sir. I can't answer that.
Okay.
I'm sorry, can you ask that question again, counsel?
Yes, Your Honor. Alcohol could be consumed in two ways, maybe more, but you could drink it or you could absorb it through your skin. My client's alleging that it was absorbed through his skin. It's my understanding your testimony is you don't have a way to differentiate the elimination rate on your device between consuming it and drinking or it being eliminated if it was brought into the body through the flesh.
Well, that's not completely true, actually. If it's in the body and it's being eliminated, it's going to be the same rate, regardless of how it got there.
That's all the questions I have.
Okay.
I am tired, but I've got a Bengals game to watch tonight, so that starts in about 2 hours. Once this is over, I'm gonna eat some dinner and I'm gonna relax a little bit, and then the Bengals game starts. So yeah, I am tired. I am ready for bed. Just to answer that question. Anyone else have any other questions? I know Heineken's been here. Heineken, my favorite troll. If anyone ever blocks Heineken's comments, I would be very disappointed. Just so you know, mods out there, he gets a free pass on everything he says.
Say something, Your Honor?
Just a moment. And so, Mr. Stradley, as to the Tether reading, there's zero doubt that there was alcohol detected on the Tether and in Mr. Sneed's body. And
We doing this right now, Leanne? Sean Williams was okay. AJ Green got old. Geno Atkins got old. Sorry. They did. They got old. If anybody shouldn't have been released, it was Jesse Bates. That's the only person I'm disappointed that we released, but he cost too much. And now he's playing awesome for, is it the Falcons? Does he play for the Falcons now? I don't know, but that's the only person that that I didn't like that we had to release. But next year is going to be even worse. We're gonna have to release Boyd. Boyd's gone next year. There's almost no way we can hold on to. You know what? Now again, I'm talking about football. You guys aren't here to watch me talk about sports. We can have a sports talk night if you guys want. I'll love that. But we're here to watch court. So let's finish this clip. There's about 5 minutes left. All right, let's go.
absorbing. The testimony is you cannot state as to how that alcohol got in there. Is that what I heard your testimony?
Yes, Your Honor. I says what I can state is that the data supports a confirmed consumption event. How the alcohol got into the individual's body, I cannot tell you how that happened. However, we can tell you that this is a confirmed consumption event based on the data and the criteria.
Okay. And in your experience, the rapid increase at 8 p.m. until it appears to be approximately, what is that, 11 p.m., 10 p.m.?
So if you look at the bottom of page 4, Your Honor, the bracelet didn't actually begin detecting alcohol until approximately just before 10 p.m. that evening.
Okay.
And then approximately
And then
an hour and a half. Go ahead. I'm sorry, Your Honor.
I'm sorry, then 11:30 p.m. is when the peak of 0.057 had been reached, correct?
That's when that was established. That's correct, Your Honor.
And given your experience with individuals that have either had absorption on their skin or consumption, in your experience, would absorption give that rapid of a rise on that rate? If it was merely absorbed on the skin as opposed to consumed?
Your Honor, we can't ascertain exactly how the alcohol got into the individual. What we can say is that there was alcohol in that individual's system. All that data supports and meets the criteria for concerned consumption event. Obviously, as the court knows, there's multiple ways to ingest alcohol, not just orally. So again, I don't know what transpired that evening, but whatever data that we have and collected off of Mr. Sneed that night supports a drinking event, Your Honor.
All right, thank you. Okay. Any other questions?
No, Your Honor, thank you.
Okay, and so Mr. Stradley, can I have you stick around for a few minutes just in case I need some additional testimony from you?
Absolutely, Your Honor.
All right, thank you. All right, and counsel, any, it sounds as though your attorney or your client wanted to say something.
Yes, Your Honor. And at first, I just want to.
All right, we got about 5 minutes left. I'm gonna let it play out the rest of the way. Who do we want to raid tonight? I haven't done one of these early live streams in a while. I've got some options. My first shot was Biggin, so that's my idea. We're gonna raid Biggin, but who do you guys want to raid? If you guys say not a better channel, that's not a good thing to say. I really gotta watch what I say sometimes. But who do you guys want to raid tonight? If no one says anything besides Biggin, we're raiding Biggin. But if you haven't liked and subscribed already, please do so. If you haven't became a Bengals fan for tonight's Monday Night Football game, please do so. If you haven't jump kicked and backflipped, please do so. And if you haven't donated yet, please do so. I'm just kidding. I would appreciate it, but I'm not going to push it any further. You guys already know where the link is. Yeah. Tonight was fun. We had a SovCit. We had a good case by Judge DiSanto. I've got a lot of court from today that I'm going to be playing over the next few days. Today was a wild day in court. All right. I'll look in the chat to see where you guys want to get redirected to or rated. So, but until next time, thanks everyone for being here. Bye.
Say we really respect the court taking the time to do this, and I know that is a big ask. If the court thinks it would be helpful, I just want to make the court aware we attempted to obtain an expert. I believe I only retained him roughly 7 days
What
ago.
did I do to you?
He interviewed with an expert that he believes will testify that this is possible. This is a possible scenario. The problem is he needed $2,500. My client can't afford it yet. If the court was willing in 30 days, my client can afford it. If he wanted to take the testimony, carry over, and he thought that would be helpful, I just wanted to make the court aware of that option, that there is an expert out there. It's my understanding that we'll come in and explain detail by detail how the absorption through the skin due to this process is possible.
And who is this person?
That is BARTON space MORRIS. And I believe he is well known. It seemed that the government's expert was aware of him as well.
And what would the relevance of that testimony be, counsel? Because at the end of the day, your client is pled guilty because he had alcohol in his system.
100%, Your Honor, and that was his mistake, but I think there's a huge difference in making a mistake. Many men get shaved with alcohol. I've done it. Almost every man has. Sometimes there's no alcohol, sometimes there are. Haircuts and shaves are very relaxing. You're not thinking about it. You still, understandably, should follow the court order, but the intention is hugely different than that and drinking, and it may influence the court's willingness to punish more severely. And in this case, not only is there a text message showing that a barber was coming, a letter from a barber, so it's not like somebody just made this up in advance to come here. There's 2 witnesses to say, I seen him get the haircut, but not only that, I fell asleep next to him, and the other guy works with him, and we drove to work together. No drinking occurring. So this is very good evidence to suggest that this may be an accidental thing. And I believe that the punishment should be much more severe if he drank beer than if he accidentally absorbed. And if the court felt that way, Mr. Morris's testimony may be able to convince the court that that's possible.
Okay, so where's the barber? Because I'm gonna tell you right now, that's who I want to hear from. Where's the barber? Because that would be less expensive than the expert.
He teaches a class. I tried getting him in today, but he was teaching a class from 7:45 to 3 p.m. If you can set it up.
Every Monday?
Yeah, every Monday, on top of traveling while he cuts hair. That's how he makes his money.
And what class does he teach?
I don't know what type of class. I have text proving that he's in class, if you want me to show you, Your Honor. He said he had class. I did ask for him to be here today.
He's in class or he's teaching a class?
He's teaching a class.
So counsel, you don't want to subpoena him?
Your Honor, and that is a trial shirt. I usually don't because the other 2 witnesses and my client could testify that he was here and he provided the letter. The only reason I don't do that, Your Honor, is because sometimes when I subpoena witnesses against their will, especially when it disrupts their job, they come in and they are aggressively negative. If the court would be willing to adjourn maybe one day for the barber to come in, if that'd be helpful to the court, we do believe he's willing to testify based on his letter.
Yeah.
Well, all right, well, let me also just say this, right? I mean, the witness may come in aggressive, but at the end of the day, the truth's the truth, right? Whether it's aggressively testified to or not.
In my experience, sometimes the truth changes based on people's disposition, Your Honor, but I understand the court's point.
Fine, you'll come back on the 6th, on Wednesday,
Thank you very much.
Thank you, Your Honor.
at 8:30.
In the morning?
Yes, I'm not going to be here 8:30 at night.
I just had to ask, Your Honor.
I can tell you that. And if the barber's not here, I don't know what to tell you. I'm not
I'll
adjourning
get
it
for
again.
you, Your Honor.
Because quite honestly, I don't know what Mr. Morris will testify to other than, yes, the skin would absorb the alcohol, right? And I think that that's been already made clear. The skin can absorb the alcohol. At the end of the day, alcohol was detected on the tether on Mr. Sneed. However it got there, it got there. So I don't know that Mr. Morris's testimony would be necessary. I want to hear from the barber.
I'll get him here for you, Your Honor.
8:30 a.m. on Wednesday morning.
Thank you, Your Honor. See you Wednesday.
All right. In person. We're back in person.
Okay.
In person.
Yes,
Same with the barber. In
Okay.
person.
We'll
All
make it
right.
happen. Thank you, Your Honor.
Thank you.
Your Honor.